Welcome to today's edition of Florida Appeals Journal. I'm Jennifer Carroll, and the question we're going to examine today is, what do you do when you get an order from the trial court sealing the court files and you don't think they should be sealed, or you get an order that's restricting you from access to pretrial discovery, or you could be a member of the press and you're being excluded from access to what you think are records that should be available to the public, or you get an order from the trial judge that imposes a gag order, and a gag order being you can't talk about the case, basically, or you can't talk about particular items in the case. Or let's say you're a journalist and you're covering, you think, as a high profile case, and there's been an order initiated by motions from the parties to exclude the press or exclude members of the public from attending a court hearing or any court hearings in the case. So what's your remedy? Can you do an immediate appeal? Do you have to wait till the end of the case? No. That's the answer is no. That's a very significant issue, of course. Obviously, you've got the First Amendment involved, right? First Amendment rights. You can challenge that order by invoking the original jurisdiction of the appellate court. So there is a specific provision in the appellate rules, Rule of Appellate Procedure 9.100D, and that's the rule that governs review of orders limiting, restricting access against the press or against the public with respect to court records and court proceedings. Now, you're aware of extraordinary writs, petitions for certiorari, prohibition, quo warranto. Technically, some will tell you this isn't a writ, but it is a means for review, and you follow the same procedure as you would when you're applying for an extraordinary writ. But again, you would follow that subsection of the rule 9.100D, and you would file a petition with the same contents, just as you would file a petition for certiorari. So you're going to, as the rule states, you're going to want to include the basis for invoking appellate jurisdiction, which of course is the 9.100D. That's the difference. And the facts, of course, which you're relying upon, the nature of the relief sought, and of course your argument with your citations and authority. So the types of orders, and I gave you examples, but these are what are commonly challenged is, again, you've got an order sealing records. You've got an order restricting access to certain records by the press, by the public, restricting access to hearings. Those are the typical orders. If you are wanting to challenge an order that restricts the press from publishing certain information, that is not within the class of orders covered by this particular provision. What you would do then is you would raise a petition for certiorari. But again, you are invoking the original jurisdiction of the appellate court. So it's considered an original proceeding. And so you would follow the standards, the procedural standards that are laid out in the rule for that. Now, you're going to want to file that petition as soon as you can, because these types of issues are, of course, subject to a mootness claim, and usually lifespan of your controversy is going to be very short. So you want to move quickly, but certainly no later than 30 days after rendition of the order that you're seeking review of. Now, once you file that petition with the appellate court, and this is something that I think is unique to these types of orders on review, the appellate court then immediately reviews the petition. They're required to immediately review the petition to determine whether a stay of the lower court proceedings is warranted. Is it appropriate? And you go by Rule 9.110D2. And under that rule, the appellate court can, on its own, grant a stay, or the party may motion, and that's usually the preferable. If you're on that side, you want to motion the court to stay. And pending a ruling by the appellate court, the clerk and the judge of the lower tribunal, the lower court, are required, you're going to treat as confidential those proceedings or records that are subject to any motion for stay. So everybody's going to treat that as confidential until you get a ruling on that motion for stay with the appellate court. And remember, any party can request oral argument, and just depending on the nature of the case, of course, the parties, etc., you may want oral argument, and certainly on the issue. The standard of review that governs these types of proceedings that applies to this petition for review and order by the trial court excluding the press or the public, it's going to be the same as the standard that is applied to a petition for certiorari. So the appellate court has to determine whether the lower court violated procedural due process or whether the order departed from the essential requirements of law. So it's the same standard that you use in a petition for certiorari. So those are the fundamental principles of dealing with this kind of issue that arises in your practice. And I will include the cases that talk about the sealing of files, the gag orders, access. There are several cases you can rely upon to support matters you'll have to address in the petition, and we will post them to our site. So I hope you find this information helpful. And as usual, if you have any questions about this topic, feel free to let us know. Thank you again for staying up to date with the Florida Appeals Journal. Hi, I'm Jennifer Carroll, and I want to thank you for watching our video. You can see more of our videos right here. Or better yet, subscribe to our YouTube channel below so you won't miss a single one.